Well, welcome everybody. I am Connie Regularly. I am here. I wanted to take a few minutes to talk to you today about the case that just came out from the United States Supreme Court on June the 17th, 2021. This opinion is the Fulton v. City of Philadelphia case about the Catholic Charities in Philadelphia and foster care and their request for exemptions in that they did not want to approve same-sex couples as foster parents. It was in Pennsylvania. They basically, Catholic Charities lost in the district court and they lost in Third Circuit. And then it went to the United States Supreme Court. And this opinion came out on June 17th, 2021. Now, this opinion here, you'll see, you can kind of look at that. Yes, you see all this? Ooh, yeah, it's a small book. It's 110 pages. It consists of an opinion of the majority, which was written by Justice Roberts. And then there is an opinion from Barrett, Gorsuch, and Alito. Now, I'm going to assume that y'all don't really know much about the United States Supreme Court other than there are 9 justices. And so I'm going to go through and just kind of name them for you very quickly. So and this is no particular order. These are just the list as it came to my mind. So Justice Barrett is a female. She was appointed in 2020 by Trump, and she graduated from Notre Dame. Clarence Thomas is a male. He was appointed in 1991 by Bush, and he went to Yale. Sotomayor is a female. In 2009, she was appointed by Obama, and she went to Yale. And Gorsuch was appointed as a male. He was appointed in 2017 by Trump. That was Trump's first appointee. He went to Harvard. Alito is a male appointed in 2006 by Bush, and he went to Yale. Justice Roberts is a male. He was appointed in 2005 by George W. Bush, and he went to Harvard. Kavanaugh, probably most of us know Kavanaugh just because of the big confirmation hearings, was appointed in 2018 by Trump, and he went to Yale. Breyer is a male. He was appointed in 1994 by Clinton, and he went to Harvard. Kagan is a female. She was appointed in 2010 by Obama, and she went to Harvard. Now, one of the important things about this opinion is that there's a lot of concurring but alternative analysis opinions in this case. One of my goals is, as a lawyer that work with people every day, is I want just everyday people to be more educated on what their freedoms are, what they look like. And more important, I want them to be able to articulate and have a conversation with legislators, especially at the state level, but also at the federal level, so they know what they need to write, what kind of laws they need to write, what kind of nuances they need to put in there so that they can protect our freedoms. Now, as you probably do know, our freedoms are articulated in our Bill of Rights, and this is going to be primarily about the First Amendment freedoms, which is the freedom of religion, freedom of speech, and freedom to assemble. All right, so I'm going to tell you a little bit about the underlying facts of the case and then tell you about the opinion of Chief Justice Roberts. All right, so Catholic Charities, everybody's probably heard that name. They have been around for well over 200 years. This opinion talks about how 200 years ago, they created a home for orphans because of the yellow fever epidemic. And then they ran asylums beginning in the early 1900s. And then when the progressive era started and they started working more with foster homes as opposed to orphanages, then Catholic Charities started a system of approving and supervising foster homes. Now, I'm a child welfare advocate. I am very interested in anything that touches foster homes because I think that there needs to be a lot of change and development and reform in that area. So Catholic Charities was doing had foster homes that they were training and approving, and they would not approve same-sex couples. Okay. Oddly, interestingly, they did approve gay and lesbian single foster parents as they did just regular single foster parents as well. but they would not do same-sex couples. Now, no same-sex couple had ever tried to be approved by Catholic Charities, which is important for you to understand. And but what happened is another agency, there was some complaint about an agency, and then a newspaper story came out about this issue in Philadelphia, which is, I'm sure, is a very blue area. Most cities are. And there was a city council investigation to protect people from discrimination. So they found out that Catholic Charities would not approve same-sex couples, and the city came in and would no longer send them referrals of children to place in foster care. And then also they canceled their contract. Now, importantly, during one of the city council meetings, and I'll talk about this again, but there was a city council person who said that they would never approve an exemption for Catholic Charities. Okay, they said that on the record, which is really one of the crux of the cases when we get down to it. So this goes all the way up to the Supreme Court. And the Catholic Charities had lost and lost at the district court and the circuit court level. And then they went for not only Catholic Charities and not only the city of Philadelphia, but there were 80 other amici briefs filed. Okay, so if you don't know what an amici brief is, yeah, I'm watching your post, your comments over here. Thank you very much. But if you don't know what an amicus brief or an amici brief is, it's when other interested organizations, or it can be persons, organizations, nonprofits, sometimes it's either even other government entities, that they write a brief on the subject as well. Here was kind of the important thing about this case going to the Supreme Court is a lot of this briefing asked the Supreme Court to overrule a 1990 case. They specifically asked to overrule this case, which is, I'm going to tell you what the name of it is here, and I've got the case beside me here, so be patient with me. There's tons of pages here. I made lots of notes. I don't know if you can see this. See all these notes I've made on here? So the case is Employment Division, Department of Human Resources of Oregon versus Smith. It is 494 U.S. 872 in 1990. Now, here was the important thing about that case, and that opinion was written by Justice Scalia. So it was an unemployment benefit case, believe it or not, made it all the way to the Supreme Court. But the result of that case was it basically said, in just plain old layman's terms, that if a law is passed that seems to be neutral on its face, that so long as it is neutral and generally applicable and was not there to target a religious activity, that it did not violate the First Amendment. Okay, so the key words are neutral and generally applicable. Okay, so when you nuance out of that, then you have to say, you have to identify if it's neutral, you have to identify it's generally applicable. Well, the neutral has to do with whether or not there's a specific target against a religious practice. So that's how you identify whether or not it's neutral. And the generally applicable is, does this apply across the board? And is the interference with the exercise of a religious practice, is that just incidental to the law? Okay, so any time that there is a law that has an articulated exception or an articulated system for defining an exception, then it's no longer generally applicable. Okay. All right. Now I know you're scratching your head and you're going, wow, it sounds like they are just making our religious freedoms too much, too technical, right? Too technical. So that was the 1990 case of Smith, and that's what I will refer to as Smith. So before Smith, there was a 1937 case, which was also a case on unemployment benefits. The 1937 case was Sherbert v. Verner, and I'm sorry, 1963. It was in effect for 37 years. This 1963 case was also an unemployment benefits case where an Indian was fired from his job because he smoked peyote as part of his religious exercise. Now, don't get hung up on the word peyote. I will tell you, when I was in law school many years ago, I remember studying this case. I got so hung up on the word peyote and trying to figure out who was smoking peyote and what they were doing and why they would be smoking peyote that I think I missed the whole point. So don't get hung up on that. But basically, that was why they denied him unemployment benefits. So in the Sherbert case, the holding was that any substantial burden on the exercise of religion must be narrowly tailored to serve a compelling interest. Now, for those in the legal world, what that means is strict scrutiny. Okay, that's the level that if the government's going to do something to impinge upon our fundamental rights, the standard is strict scrutiny. What is the compelling interest of the state? And is it narrowly tailored to fit those interests? This is a huge argument. I've tried to make these arguments. I brought constitutional challenges before. I'm telling you, the Attorney General's office will dig their heels in to defend any law written by the legislature. So at the end, so as I finish this, I'm going to be interjecting about some of the things that our legislators need to do to protect our rights. Okay, so in this particular case, Justice Roberts looked at the policies and the contracts. So in the Catholic Charities contract with the city, there were two non-discrimination clauses. Okay, there was a non-discrimination clause in what they referred to as Section 15.1, which said there would be no discrimination. And then there was a whole different clause, though, that was Section 3.21. And in Section 3.21, what it said, the phrase was that the provider shall not reject a child or family, including but not limited to prospective foster or adoptive parents for services based on their sexual orientation, unless an exception is granted by the commissioner or the commissioner's designee in their sole discretion. So within the very contract, they had written in a possible exception. Now, that exception was left up to the discretion of the government, but it was a system for creating an exception. Okay, got that? All right. So now as Roberts goes through this, basically, Roberts ultimately says, hang on. Okay, so what Justice Roberts says is because they created that system of exceptions within the contract, that the question was not whether or not the city had a compelling interest to enforce non-discrimination policies generally, but whether it has such an interest in denying an exception to Catholic Charities. Okay, so do you see how it sounds a little bit backwards to the layperson? It's basically saying that this general law, the general and neutral law, might have been okay had they not created this exceptions. And since they created a system for exceptions, the constitutional question became whether or not they had a compelling interest to deny that exception. The city came in and that they said that their compelling interest fell into three categories. One was maximizing the number of foster parents. The other was protecting the city from liability. And the third was ensuring equal treatment of prospective foster parents. And basically, Justice Roberts says that's not good enough. Those are general, they're not specific. And so therefore, it does not pass muster. The other issue that had been raised and had argued was that there was an ordinance in the city of Philadelphia that is the Fair Practices Ordinance. And this is basically what's called the public accommodation. So if you're a public accommodation, you cannot discriminate. Now, some people remember the Masterpiece Cake case out of Colorado, and this was one of the arguments and one of the things that was created, that was argued under the Masterpiece Cake, was that he was a public accommodation. And so Justice Roberts says, no, foster care is not, services are not in a public accommodation. So basically he said, I don't even have to go there. All right. Now, the next opinion, so that is Justice Roberts. And Justice Roberts wrote the majority opinion, which becomes the order of the court, which means that the case, the Smith case, the 1990 Smith case, remains in effect for considerations of religious freedoms. So religious freedom, if a law is neutral on its face and it is generally applied, it does not insult religious freedom on its face. Okay, now, for instance, let's say that there is let's say that there is a law for a lot of laws have been covered by the legislature. So now they've sort of written some exemptions in, but they're going to have to do more is sort of the theme to this discussion. For instance, let's say they have a general categoric law that men are not allowed to wear a head covering in court. Okay. So what that would do, that would interfere with the religious practices of Orthodox Jew. So let's say they had a general law, let me see, that categorically said that all wine, that they banned all wine. Let's just say that. And in this analysis, actually, as given by Alito in another opinion, he said that would then prohibit the celebration of Catholic Mass. So there may be a general and neutral law that infringes upon a religious practice, but there has to be a showing that it was not neutral, meaning they were targeted, and that it was not generally applicable, which meaning there were exceptions written into the law or a systematic way to create an exception. Do you understand that? Do you understand that? Okay. All right. Now let me tell you a little bit about what the other opinions discussed generally. All right. So generally, we had an opinion written by Barrett. And Barrett's opinion, and ultimately Roberts says we don't have to touch Smith. We don't have to use this case to touch Smith. Okay. Which a lot of people asked them to specifically review, and they didn't touch it. All right. Now, Barrett, in her opinion, was joined by Kavanaugh and Breyer, and they say they joined her opinion except for the first paragraph. Basically, her first paragraph was kind of a little bit nonsensical about if we're going to overrule Smith, what are we going to put in its place? What should replace Smith? And saying that the prevailing assumption seems to be that strict scrutiny should apply whenever a neutral and generally applicable law burdens religious exercise. I am skeptical about swapping Smith's categorical anti-discrimination approach for an equally categorical strict scrutiny regime. Particularly when the court's resolution of conflicts between general applicable laws and other First Amendment rights like speech and assembly have been much more nuanced. In a way, that part she's right. However, she makes another comment down here, basically saying there's been a longstanding tenet of our free exercise jurisprudence that both predates and survives Smith, is that the law burdening religious exercise must satisfy strict scrutiny if it gives the government officials discretion to grant individualized exemptions. Well, as Alito will say in his opinion, she's wrong, and she doesn't cite any cases. So Alito kind of poo-poos her and says she doesn't really know what she's talking about. Remember, she is the newbie on the bench. All right, then there is a 77-page long opinion by Alito. He is joined by Justice Clarence Thomas and Justice Gorsuch, and then Justice Gorsuch writes his own additional opinion. But Alito, through 77 pages, first of all, very, very critical of Roberts, in saying that he did not the Fair Practices Ordinance, that instead of applying the city ordinance, that Roberts looked at the state ordinance, and so therefore and there was no reason for him to do that. Alito and Gorsuch also say that Roberts was wrong in looking at the entirety of the contract instead of just the 15.1 section. And this is very questionable, because Gorsuch kind of says, now you've taken one contract and you've combined the restrictions and the exemptions across the entire contract. However, that section 3.21 does include foster parents. So it's sort of a nuanced argument, very aggressive argument, but not sure that I necessarily agree with that. Like, they care what I think. Okay. I totally get, they don't care what I think. Alito spends a lot of time talking about our laws that are written categorically, and that our legislators should be writing laws for public peace and safety. But on the other hand, there are a lot of laws that are written that really do not affect public peace and safety. For instance, laws about appropriate dress in a courtroom, or laws about putting your trash out on the side of a road. I mean, there are so many laws out there that are not about public peace and safety. So he spends a lot of time talking about that and how those exceptions might be derived. And he also is very critical in saying that, indeed, foster care is a public accommodation just as much as a college is, because not everybody gets into a college, and not everybody gets to be a foster parent, but both systems are open to public applications. So he was very, very critical of also not considering foster care as a public accommodation. He does talk about how he mentions a couple other cases. He does go back and talk about the Sherbert case again, and saying that the test distilled from Sherbert, that a law that imposes a substantial burden on the exercise of religion must be narrowly tailored to serve a compelling interest, was the governing rule for 37 years. Okay, that's true. That's true. And he does mention a couple other cases, such as the Yoder case, where Amish parents contested the law that required mandatory attendance in school until a child reached 18, and they did not want their children to be required to go to school, especially when they were older. And so this went all the way up to the Supreme Court, and the Amish won because there was not a compelling state interest in that. Again, this is a law that's not necessarily written for the public health and safety. So let me flip through here. Now, he's kind of critical of Scalia when Scalia wrote the Smith opinion, and saying that Scalia did not distill the very simple language of the First Amendment when he wrote that opinion, and he really kind of added his own characteristics to the First Amendment. Now, I want to talk about how this affects lawmaking. Because Alito says that where this has left our law, or where this puts the status of our law. It says, if a law prohibits conduct that constitutes an essential religious practice, it cannot be said to prohibit the free exercise of religion unless that was the lawmaker's specific object. Okay? So, as we talk to lawmakers, the one thing that lawmakers need to understand is that they need to create a way for these specific exemptions. Now, America was a Christian nation, is a Christian nation, was created on the Christian foundations. We all know that. over 200 years. There are lots of different religions, and they have lots of different religious practices. And I can't sit and name them all, but we have Jews and Muslims and Amish and Christians, and the list goes on, and different ones have different kinds of religious practices. I'm not going to make this discussion about some of the religious practices that might ultimately be harmful or that we may not want to be challenged with. But I think for the protection of people like Catholic Charities, our lawmakers, because remember, the Catholic Charities won on their contract and not on the law, technically. So the lawmakers need to build in when there are certain restrictions, and maybe they just need a general law that says that the First Amendment, freedom to exercise a religion, shall be protected by allowing for a system of exemptions to be heard and limiting the state or requiring the state actors to produce a compelling state interest in that, to that effect. Maybe that needs to be a standalone law that would then compel, in case the lawmakers missed it, that it would compel the government to make sure that they're not impinging on religious freedoms. Okay, I want to thank you all for joining me today. I like to keep things under 30 minutes, and so I'm going to conclude here. You might want to listen again. It's complex, but again, my goal is to make you more articulate and educated to be able to talk to your lawmakers at a state and federal level. So in sum, what you need to understand today is our First Amendment right to exercise our religion can be infringed upon by laws imposed that are generally neutral and generally applicable. And that if it just happens to infringe upon a religious freedom, and that was not the target or the object of the law, that it is not subject to First Amendment scrutiny. However, if there is that exemption, then the state actor, the government agency, is required to show a compelling state interest to deny that religious exemption. That's in sum. All right. We'll see y'all. Have a good Sunday afternoon. Happy Father's Day to everybody. And we'll be talking again soon. Thank you.